Alright, so this video is really just about, does, what benefit can I get that's tangible, that I can test, that I can use to prove that Anna's basic package of editable forms plus the Foreign Sovereign Immunities Act, how can it help me? How can I use it in real life rather than just being recorded and sitting there waiting for someone to look it up in case they want to? And so Anna had three answers to that. One came out called The Indemnity Bond and Court Process Step by Step. And so what I'm going to do is I'm going to look at the 1105, the 1147, the 1233, and the 1162. And then I'm probably going to end up having to do another video on 1174, the update on the process. So, because I didn't do that in the last video, which was the basic editable forms video. So let's go ahead and open this one up. This is the 1105. And we're just going to read through it. The indemnity bond and court process step by step. The indemnity bond and court process step by step. In order to conduct business across state borders, which we all do, we have to either function in private or public capacity. If you're a public corporation and functioning in the realm of the international commerce, you are insured by your parent corporation as a franchisee. If you're a private person functioning in the realm of international trade, you are indemnified by your country and its assets. Notice the words commerce versus international trade, insurance versus indemnity bond. Two different jurisdictions, two different political statuses, two different forms of business transactions, two different forms of insurance. Commerce is business between incorporated entities. Trade is business involving unincorporated entities. When you engage in trade, you use your trade name, which is styled upper, lower case, first, middle, last, if you will, John Michael Doe. Trade is internationally protected, commerce is not. We claim to back your country and your assets for you, now this is Anna speaking, and issued a state-by-state indemnity bond. This allows you to operate as a private person engaged in international trade, and nobody can say otherwise. It is part of the rebuttal proof that you are not operating in any public capacity and not subject to statutory or municipal law. When you walk into court, and this is the exciting part, and present certified copies of your deed of reconveying your trade name to the land and soil jurisdiction and your certificate of assumed names and your indemnity bond number, for example, RA 393427640 US, California, or whatever state you were born in, and your revocation of all powers of attorney, you have delivered a crushing series of evidences and pre-recorded motions. And a deed is a motion in the public court record. You walk in, now this is what you do, and I've had a friend do this twice in court, and jaws were dropped, and it was silence, and nobody wanted to see any of his paperwork. Alright, I believe he had a violation or something where he was pulled over and didn't have plates or something like that. You walk in, and while standing outside the bar that separates the judge, etc., from the gallery, wait for your name to be called, and when it is, make sure your court recorder is recording. Then stand up and say, I am here in the matter of John Doe, and I invoke trial by record and public law. Then you lay down the birth certificate and say, Your Honor, this birth certificate was issued in my name in error. I have reached the age of majority and I do not elect to be franchised. And she puts in parentheses, boom. And then you lay down your deed of reconveyance and the diagram of the fraud. Alright, so that's telling you right there that when you do the recordings, you really should record the deed of reconveyance and the diagram of the fraud included in that package, okay? And you lay down the deed of reconveyance and the diagram of the fraud, showing that your missing trade name is at the center of this issue, and you say, as this diagram and this public deed of reconveyance shows, I was presumed to be lost but now am found alive and standing on the soil and land of my birthright. I am the original possessor and entitlement holder of the missing trade name, and I am owed all beneficiary I am owed all beneficial reversionary trust interest in it and any derivatives thereof. And she writes, boom, boom, after that. Folks, when I first read this, I fell out of my chair. I mean, I was like jumping up and down because I had been waiting for, what do we do? Then you lay down your certificate of assumed name and you say, as this recorded certificate of assumed name shows, I have seized control of all assumed names related to my trade name and corrected their domicile to, as of the date shown. Boom, boom, boom. Then you lay down your private registered indemnity bond number and you say, I and my vessels are all private persons engaged in peaceful international trade, and any other presumption is made in error. Here is the indemnity bond on file with the United States Treasury demonstrating our private capacity. And then there's four booms. Boom, 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 boom. And, I want to say, too, that you want to make sure that you're reading into the record, because you can have this with you and just read it. You don't have to memorize all this. Goodness sakes. Just get up there and read it into the record, but read it slow and be loud. Then you lay down your revocation of all powers of attorney and you say, this is my revocation of all powers of attorney. I am the only attorney in fact, and I object to any and all other presumptions of this court and its officers. And then there's 5 booms. Boom, 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 boom. All right? Maybe that was 6. Then you say, does the court administrator wish to examine the records? If the judge says yes or nods, hand the paperwork over the bar to the bailiff to carry to the judge. While they're shuffling around, or if they decline seeing the paperwork, say, I serve notice on this court that I am tax exempt and that all vessels related to my name are tax prepaid. I serve notice on this court that I am owed the law of peace in all military venues. I serve notice on this court that my vessels are all permanently domiciled on the land and soil of New York, in my case. I serve notice on this court that my vessels are owed the general session law and public law and are not subject to any private statutory or municipal law administered by this court. And again, you're going to be speaking this a lot slower and louder. Then pause a moment, and then it says, I wish for the complete elimination of all claims and dismissal of all charges related to this matter with prejudice. I wish to be compensated by the prosecutor in the amount of $5,000 for this trespass upon my person. It can be more if you have been severely bothered or incurred more expense than just the trip to the court. I wish for the court administrator to properly discipline court personnel to prohibit the bringing of such false claims in the future. And now I am leaving this foreign vessel in dry dock, and I do not expect to be further misaddressed. Give the judge a long stare and look around. My buddy did this twice. Then turn on your heel and exit without stopping to answer any further questions. The judge could call your name. He could say anything. He could say whatever he wants. He could demand everything he wants. And I'm adding this. Without looking back, and certainly without paying any attention to anyone or anything short of a direct physical attempt to stop you, which would result in a constitutional level complaint against the court under Article 4, Section 1 and 2. You just keep walking and you get the heck out of there. It's time that you all learn how to stand up for yourselves against these bullies, and also how to help defend each other. Anyone can appear as a counselor at law to assist you. In fact, the more witnesses you can bring with you, the better. There is no need to stand up when the judge enters the courtroom, because they are acting as a court administrator and they are not carrying a copy of the Bible, which is the whole reason that people ever stood up when judges entered the courtrooms in this country to begin with. I hope, pray, and trust that giving you all a blow-by-blow example of how to use the indemnity bond in a court case, you can all finally see its function and the reason it is important as evidence that you are functioning properly. It is important as evidence that you are functioning properly in a private capacity. Sometimes I get a little tongue-tied there. And so that's the 1105 doc, and now I'm going to pull up the next one. You don't necessarily read these in order. You really have to kind of study. The first one that came out was great. The 1147, I haven't looked at it in a little while here, but I try to read these like at least once a week. Okay, this is 18 USC 911. This is fantastic, people. You gotta really print these out and highlight these. Okay. To explain to those who didn't understand what I was talking about when I referenced more ammo in the Territorial United States Code, here is what 18 USC 911 actually says. Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. So just think about this. Before we all woke up, we might read, and I think I did read this a while ago, maybe a couple years ago. I wasn't quite as deep into it as I am now, but I read 18 USC 911 one time, and you might think whoever falsely and willfully represents himself. So you might think of like someone coming over the border from another country, and they come over and they represent themselves as a citizen of the United States. Well, they can be fined or titled or imprisoned not more than 3 years or both. Well, you might think, well, that's a good thing. We don't want. I mean, if you believe you're a U.S. citizen and you have rights, and I'm a U.S. citizen, that's special. And if someone comes over and they impersonate a U.S. citizen, then that they should get punished. But when you wake up, you realize, wait a minute, hold on a second. I don't want to be mischaracterized as a U.S. citizen or a citizen of the United States. So here's something that I could use against the courts. And let me read on. Now, as part of reclaiming your birthright status, and by the way, this is for educational purposes only. It's not legal advice. I'm just reading an article. Now, as part of reclaiming your birthright status, you have to face the fact that you have made some mistakes. You have claimed to be a U.S. citizen more than once, and now that someone finally explained that they aren't talking about the same U.S. that you are, you realize that you were never a citizen of the territorial or municipal United States either. Now that the deceitful language is exposed, it's clear as day that you weren't born in and don't desire to be in the same political status as someone from Puerto Rico, right? Right. Nothing wrong with Puerto Rico. So here you are, and I don't think that inferred that at all, but don't be offended. So here you are in front of the judge, and you're saying, hey, look, there's been a mistake here. I've been misidentified as a federal citizen, and I'm not. I'm not one. This wasn't anything willful on my part. I was just misled to which United States was being referenced and not told about the obligations of citizenship. I wish the court, now wish is a powerful word coming from a sovereign. I wish the court to take notice of my actual political status and desire to exercise my reversionary trust interest in my choice to correct the records and reconvey my given name to the land and soil of California, for example. Okay, so you have said your whole spiel. What's the judge going to say? You can't make mistakes? You can't correct them? Hardly. And your admission that you made a mistake holds the court harmless. So he now has what he needs to be able to provide you with the relief from the situation. What's the final stone that has to turn? Well, you have to encourage the judge to do the right thing, and this is where the 18 USC 911 comes in. You stand back and say, and Your Honor, I can't help but notice that now that I know I am not a federal citizen, it would be a crime for me to pretend to allege otherwise according to Title 18, Section 911. What's he going to do? Openly promote crime and force you to commit crime from the bench? Openly breach federal code? You're just doing your duty. You did not willfully pretend to be a federal citizen. You didn't even know what that meant, and according to your testimony, you weren't told either. You just found out about all this stuff, and now you're trying to correct that honest mistake. If the judge in your case doesn't let you correct the mistake, he's aiding, abetting, and enforcing the commission of a crime. And for that, he can lose his job and his bar card. That's pretty good encouragement for him to do the right thing. But you still have to ask for relief. In view of this whole circumstance, Your Honor, I wish that the registration of my trade name be stricken and that this present case be eliminated from the record. It can't just be dismissed because then there's a record of dirty laundry as part of the requirement to hold the court harmless. There can be no record held against them. Thus, you ask for the elimination of the whole proceeding. Most judges will then issue a sealed order to the Bureau of Vital Statistics telling them to get your trade name removed from their registration system pronto. After that, records concerning you will be kept in the Secretary of State's office or the office of the Lieutenant Governor. The judge may hem and haw and want to chew on all this to gauge his options. These guys have been operating as crooks under one set of mandates for a long, long time. They don't go down easily. He may even try to find an excuse to get up and leave the courtroom. If he does that, you know what that is. That is switching up and changing the jurisdiction of the court to a higher level. When he comes back in and the proceedings resume, you want to say, I take notice that the court may have changed its jurisdiction. May I inquire what jurisdiction of the law the court is now invoking? It is at that point, on or before that, 99% of judges will turn tail and run for shelter. Why? In the first instance, you've already beaten the dead horse. If he continues to mess with you, he commits a crime or becomes an accessory to one if he fails to recognize your actual political status. In the second case, where he has changed the jurisdiction by leaving the court and re-entering, he has upped the ante for himself and you, and he has to dread that the next words out of your mouth are going to be, "As a living soul, Your Honor, I beg leave to appeal." And at that moment, he sees his entire career, his pension, everything sliding down the drain. Even his brothers on the circuit court can't save him. All will be revealed. He has to get rid of your case or else. So you repeat your kind offer. I wish for the registration of my trade name to be stricken and for the elimination of his case from the record. If you have a really obdurate judge, he may hem and haw some more. Whatever he says at that point is immaterial. You have your request for appeal on the record and hanging over his head on one hand, and you have the option B, the get out of jail card, for both of you in the other hand. What's he going to choose? If he hesitates, just repeat your offer 3 times as a charm. This is why 18 U.S.C. 911 and other negative enactments are so very, very useful. They are the teeth of the law. Negative enactments serve to keep judges honest, especially as regards this central issue of political status and citizenship. This is why 18 U.S.C. 911 is important. It is a fundamental tool that you can use to enforce recognition of your non-citizen status and their lack of general jurisdiction over you. It is the same way with the IRS. Once you realize that you are definitely not a quote-unquote withholding agent, which is a warrant officer in the British Merchant Marine Service, it is a crime of impersonating an officer for you to claim to be one. And if you claim to be a withholding agent under penalty of perjury, another crime of perjury is added to your list. Obviously, the court cannot force you to commit a crime. Your Honor, there's been a mistake. And so that's the 1147 document, known as Additional Explanation about 18 U.S.C. 911. And let's go ahead and open up another one, 1162, I believe it is. Yeah. Magic words. This is one of my favorites, and I'm going to go ahead and just take a pause here on this one and step back in a minute. All right, so we're back now. I just want to let everyone know that that I don't edit right now. I haven't edited anything. What I do is I just hit F7 and it stops it. It pauses it, and then I come back and hit F7 again, and it starts. So I can take a bathroom break or have lunch or something like that, and just come back and pick up where I left off. Otherwise, this would be really long and drawn out, and my voice is already kind of going through some rough patches right now because I've had a 3 or 4 hour conversation with somebody today who suggested that I make these videos. So I decided to do so. Excuse me. Alright, so this one is called Magic Words. It's one of my favorite articles she's ever come out with by far. Faced with foreclosure. Now she's telling you what kind of examples you might use this particular article in, because it also has a step-by-step like what to do kind of script. Faced with foreclosure, child custody theft, federal taxes, when you are not a federal employee, corporation, or dependent, fine. Here's what you do. You immediately request a status hearing. You walk in, and when your name is called, you stand up right there where you are. You don't go through the gate and cross the bar at all, and this is what you say. Now again, this is not intended to be legal advice. This is for educational purposes only, and I am reading an article written by somebody else. For the purposes, by the way, of training the jural assemblies. All right, the county, state jural assemblies that are coming alive all over the thousands of counties that are out there in the across the land. See, I almost said it. I almost said in the United States. It's really hard, guys, it's really hard to change back to the way it should be. We've been taught wrong all along. We've been taught we have a first, middle, last. We weren't taught that we have a given name and a surname, but yet if you look at your passport, what does it say? Given name, surname. There's a reason for that. So, back to where we were. You walk in, and when your name is called, you stand up right there where you are. Don't go through the gate and cross the bar at all. And this is what you say. There's been a mistake. I'm here today in my true and natural capacity as one of the living people of New York, and I wish for this entire case to be dismissed with extreme prejudice and eliminated from the court record. Now this gives the judge his hold harmless to act in your favor. I am the priority creditor and the employer in this courtroom, and I am fully indemnified against loss or damage by indemnity bond AMRI 4 zeros and a 1 RA 393427640 US on file at the U.S. Treasury. I am exercising my reversionary trust right and my exemption from the jurisdiction of this court effective on your birthday. And you say what your birthday was, your actual birthday. I wish to be paid treble damages by the prosecutor in compensation for my time losses and inconvenience. This is about as cut and dried as it gets, she says. Chances are they will stare at you like a talking horse and may ask you to repeat what you just said. Anna's funny. I don't know whether I should call her Anna or Anna. I had an aunt, Auntie Ann, when I was growing up, so I usually say Ann instead of An. But Anna, I've heard many people refer to her as. So this is about as cut and dried as it gets. Chances are they will stare at you like a talking horse, and I can't even say it without laughing, and may ask you to repeat what you just said. Repeat it. About that time, sphincters are closing. Sorry. If the judge, court administrator asks for additional instructions, say, I wish for any and all charges to be offset by mutual offset credit exchange as guaranteed by the congressional intent of House Joint Resolution 192 and established as Public Law 73-10 and UCC 3-104C. I wish for the regulations to be followed to the letter by the claimant and the claimant's bank. You must obtain my signed acceptance of the billing on the face of the billing statement, and the claimant's bank TTL officer must return it directly to the Secretary of the Treasury for certified funds deposit in that amount in the claimant's account. You're reading this into the record, folks. When the original signed billing statement is received by the Treasury, as indicated by the date on the green return receipt card used by the bank TTL officer to send in the claim, the clock starts running according to Federal Window Regulation J and Federal Reserve Regulation Z, Truth in Lending, 12 U.S.C. 226.1. On the 16th day after the green card is returned, the claimant's bank TTL officer is enabled to credit the deposit to the claimant's account. And that bit of bookkeeping settles the account. I have been greatly inconvenienced and wished for just compensation from those responsible. In the case of the seizure of your children, and Anna's making a statement here, in the case of seizure of your children, this billing statement is going to be astronomical, and no judge in his right mind is going to want to present it to you, but you must insist on seeing the billing statement related to the case, or there is no case, which is the logical out for the judge. Simply dismiss with prejudice and beat feet. Otherwise, the losses to the company will result in him losing his job. Since you are dealing with a bankruptcy on top of everything else, you will want to bring certified copies of your BC, and your deed of reconveyance and your certificate of assumed name to court with you. If you are in child custody matter, you will want to bring certified copies of your baby deed also. All right. I assume you want the baby deed to be for the child in question. If the judge wobbles, wave the bailiff over and give the certified documents to him to deliver to the judge for the judge's review. These are very powerful intellectual property and private property issues. If they get caught pillaging Americans, they can be fined $250,000 and spend 10 years in jail. If they get caught mischaracterizing and kidnapping Americans in violation of the Geneva Conventions, they can face a firing squad. More the reason I want common law drill assemblies. You know how many times it's going to take for a firing squad to happen live or whatever, for these people to get their ducks in a row and beat feet and get their ships in dry dock off our land. It won't take long at all. The more people who exercise their exemptions, the quicker we will all get court reform. Assuming that they decide to play ball, the judge will return the bill to you for your acceptance. Write, accepted in all caps, and then lowercase, for full and complete settlement. And then write AMRI in caps, 4 zeros and a 1, RA 393427640, spaced apart, and then followed by US, and then Ohio in brackets, or in parentheses. and then do a byline and sign first, middle, last, and then put a date underneath that. Give it back to the bailiff. The prosecutor is required to bring his checkbook to court and to be ready to write you a check. So look at him expectantly. If he doesn't have his checkbook, he is in critical meltdown condition. He suddenly owes you 3 times what he was claiming against you. Wow. The judge is going to be extremely disgusted. The company profits just took a dump. Let it all roll. If anyone says anything to you, you just bat your eyelashes and say, I have exhausted my administrative remedies. And keep saying that until the scurrying and bobbing and dodging has ended. Then say, good day, gentlemen, and walk out with a backward glance, and despite whatever they might say or call after you, you are sovereign. They are the employees. Whatever difficulties you have done your part. And I like it because Anna has an article that says, you might have to talk in Tarzan speech. Me employer, you employee, kind of thing, like me Tarzan, you Jane. Oh, all right. So that's about it for these 3 articles. While I'm at it, I'm gonna just pull up the 1174. So if you're not interested in learning about the 1174, which is an update on process on top of the 928 and 839 docs that I already did another video on. But I'm going to go ahead and look at 1174, updates on process. Let's go ahead and open that up real quick. And I'm not going to read the whole thing, I don't think. But Anna says, okay, campers, and more insight into the history and the process and the rest of the story. What you need to have ready to counterclaim back your good name and estate. 3 authenticated copies, or if not possible for your state, certified at the state Secretary of State level, and at least one authenticated at the U.S. Department of State level copy of your birth certificate. These are private documents, not to be recorded. 2 notarized statements from witnesses who know you, your family, and have firsthand knowledge that you are the person who was born to the parents and at the place and time shown as the actual birthday on the BC. If possible, a lineage treaty showing that your family has been in the country since before the Civil War, 1860. This is just a simple recitation of your parents, grandparents, great-grandparents, when and where they were born, and when and where they got married, etc. Revocation of all powers of attorney effective the day of your birth. I believe that's kind of built into one of the editable forms. The deed of reconveyance is one of the editable forms. The certificate of assumed name is one of the editable forms. The mandatory notice of liability. And then an international will clearly establishing your disposition of your property interests. All this turkey trot is the full-blown, insurmountable, stick-it-down-their-throat sideways seizure of control of your name and estate back from the vermin, valid in every international court on earth. If they make the mistake of addressing you as a federal citizen, you request a status hearing and blow them clean out of the water. So thanks to the work we already did, this is Anna talking, you were free to assign the BC Trust to the U.S. Treasury 1789 from whence it came, and you can go through the additional work to establish your own private indemnity bond, but you can also just tag along and use the indemnity bond established to protect you and your actual State of the Union. This looks like an A for V process, but it is not. Now, guys, this is real important stuff. I should almost do a whole other video on this. I think I'm going to go ahead and do a whole other video on the indemnity bond process that's kind of taken the place of and looks like an A for V, this part right here, because I have not totally figured this out yet. It's kind of new to me, but I'm going to go ahead and end this video here and just probably do a whole other video on this as I do a little more research and get a few more answers from Anna. I appreciate your time, and hope this helps you guys out. Thanks.